I spent 17 years at Dalton and Reed. 17 years of quiet reliability. I wasn't the VP who spoke at conferences. I wasn't the director who posted motivational quotes on LinkedIn. I was the person who made sure the contracts actually worked. My name is on 743 service agreements. I know because I counted them later, sitting at my kitchen table with a mug of cold coffee and a growing sense of something I can only describe as clarity. They called it misconduct. That's what the termination letter said. Violation of company policy regarding unauthorized client communication. Signed by Marcus Webb, our new Chief Operating Officer, a man who'd been with the company for 11 months and had never once asked me how anything actually functioned. The meeting lasted 4 minutes. I know because I watched the clock on the conference room wall, the one with the second hand that always stuck at the 47 mark before jumping forward. Marcus sat across from me with Danielle from HR beside him, her hands folded over a manila folder she never opened. "We've received complaints about your communication style with clients," Marcus said. He didn't look at me. He looked at his phone, which he'd placed face up on the table between us. Multiple complaints about professionalism. I'd worked with most of our clients since before Marcus was out of business school. I knew their contract renewal dates. I knew which ones needed quarterly check-ins and which ones preferred to be left alone until something broke. I knew that Thompson Industries always paid 30 days late and that Veritech would try to renegotiate terms every 18 months like clockwork. "Which clients?" I asked. "That's not really the point," Danielle said, her voice soft in that particular HR way that sounds like empathy, but means liability protection. "It is the point," I said. "If there are complaints, I'd like to address them." Marcus finally looked up. "The decision has been made. We're restructuring client services. Your role is being eliminated. The complaints are simply the documentation we need." I understood then. This wasn't about complaints. This was about salary. 17 years of incremental raises, of cost of living adjustments, of bonuses that accumulated into a compensation package that looked expensive on a spreadsheet. Marcus had probably never seen me work. He'd only seen a number. "I see," I said. "We're offering 2-week severance for every year of service," Danielle added, sliding a document across the table. 34 weeks total. It's quite generous. I didn't sign it. I took the document home. That night, I sat at my kitchen table, the same one my father built in 1987, oak with hand-turned legs, and I read the severance agreement 3 times. Standard confidentiality clause, standard non-disparagement language, standard release of all claims. Then I pulled out the box from my hall closet, the one I'd been meaning to digitize for years but never got around to. Accordion folder, brown cardboard, labeled DLR 2008 to 2012, in my own handwriting. I wasn't looking for anything specific. I was just looking. The original contracts were in there. Not the current versions we'd migrated to the document management system. The originals. The ones I'd drafted when Dalton and Reed was still small enough that everyone knew everyone's birthday. I found it in the Thompson Industries file. Page 17, Section 8.4, Subsection C. A continuity clause I'd written myself, negotiated after their previous vendor had disappeared mid-contract and left them stranded during a critical product launch. In the event of personnel changes affecting the primary account manager, client reserves the right to approve replacement personnel or terminate the agreement with 30 days' notice and no penalty. I'd written identical language into 47 contracts between 2009 and 2013. It was my signature clause, the thing I'd insisted on after watching too many clients get burned by vendor turnover. Management had always approved it because it made us look stable, professional, committed to continuity. I was the primary account manager on 39 of those 47 contracts. They were still active. I'd checked the status that morning from my work computer, before they disabled my access. Thompson Industries was up for renewal in 6 weeks, Veritech in 3 months. Helios Logistics had just signed a 5-year extension last quarter, based largely, according to their VP, on our trust in you personally, Linda. I sat back in my chair and let the thought settle. Marcus had fired me for misconduct related to client communication. The problem was, the clients legally had a say in who managed their accounts, and no one had asked them. I didn't call anyone that night. I slept. Not well, but enough. The next morning, I made coffee, cleared the table, and laid out the contracts in 3 neat stacks. Those with the continuity clause where I was primary, those with the clause where I was secondary, and those without it. Then I opened my laptop and did something that, apparently, now qualified as misconduct. I wrote emails. Not from my Dalton and Reed address, of course. They'd shut that down by 4 p.m. the previous day. From my personal account, subject line, transition update. I wrote to each client individually, no mass mailing, no BCCs. 17 years had taught me that people can smell generic communication through the screen. I told them the truth. As of yesterday, I am no longer with Dalton and Reed. I was informed that the company is restructuring client services. I wanted to reach out personally to thank you for the opportunity to work with you over the years and to ensure you have what you need during this transition. I did not disparage the company. I did not speculate. I attached nothing. I mentioned, delicately, the continuity clauses where they existed. As you may recall, your agreement includes a provision regarding changes in primary account management. Please review Section 8.4c at your convenience to confirm your options. If you have any questions about past work or context, I am happy to share my institutional knowledge in any way that is appropriate and compliant. I hit send on 39 emails. By noon, 12 had replied. By the end of the week, 36 had. Thompson Industries was the first to invoke the clause. Their CEO called me directly on my cell, a number I'd given him 4 years earlier during a system outage crisis I'd resolved at 11 p.m. on a Saturday. Linda, what the hell is going on over there? His voice had that edge of someone whose trust had just been violated without warning. Nobody told us you were leaving. We got an email this morning from some kid named Brett introducing himself as our new strategic partner liaison. I wasn't aware I was leaving either until Thursday, I said. Marcus Webb made that decision. Marcus Webb doesn't know us from Adam. You built this relationship. We renewed last year specifically because you understood our deployment cycles. He paused. I'm reading this continuity clause right now. We put this in for exactly this reason, didn't we? We did. Then we're invoking it, effective immediately. I'll have our legal team send the termination notice today. 30 days, no penalty, just like it says. Veritech followed on Monday, then Helios, then Continental Services, Pacific Rim Technologies, and 11 others in the span of 10 days. I didn't ask them to leave Dalton and Reed. I simply reminded them they had the option, and they made their choice based on 17 years of evidence that I delivered what I promised. Marcus called me on day 12, not from his office number, from his cell, which told me HR wasn't in the room. You need to stop contacting our clients. His voice was tight, controlled in that way people get when they're furious but aware they might be recorded. I sent one email to each client I'd worked with, I said, from my personal account regarding a professional transition. I didn't solicit business. I didn't disparage the company. I stated facts. You told them about contract clauses. I reminded them to review their existing agreements I wrote. That's not solicitation, that's professional courtesy. This is tortious interference. No, Marcus, it's not. My voice stayed level. 17 years of dealing with vendor disputes had taught me exactly where the legal lines were. Tortious interference requires improper methods or ulterior motives. I used no confidential information. I made no false statements. I simply informed clients of their contractual rights under agreements they already signed. The silence on his end lasted long enough that I thought he'd hung up. "We'll sue you," he finally said. "You're welcome to try. I haven't signed your severance agreement yet, which means I haven't waived any claims. If you sue me, I'll countersue for wrongful termination and produce the discovery showing there were no actual client complaints. We both know there weren't. You fabricated misconduct to eliminate a salary line. That's retaliation, and it's actionable." I heard him breathing, not angry breathing, calculating breathing. "What do you want?" he asked. "Nothing from you. I already have what I need." I hung up. By week 3, 19 clients had terminated their contracts with Dalton and Reed. The company lost approximately $3.7 million in annual recurring revenue, based on the contract values I knew by heart. Marcus would have saved maybe $180,000 by firing me. The math wasn't complicated. The clients started calling me with a different question. Could I help them independently? I hadn't planned to consult. I'd planned to find another position somewhere stable, somewhere that valued institutional knowledge. But 19 clients asking the same question creates its own kind of clarity. I registered an LLC on a Tuesday, Conway Consulting Services, named after my mother's maiden name, filed for an EIN, opened a business bank account, set up a simple website with a contact form. I didn't advertise. I didn't need to. The clients already knew my work. Thompson Industries was my first contract. Same scope, same terms, 40% less than what they'd been paying Dalton and Reed because I didn't have Marcus's overhead or Brett's strategic partner liaison salary to cover. Veritex signed the next day, then Helios. Within 6 weeks, I had 12 active clients and a revenue projection that exceeded my old salary by a factor I found slightly embarrassing to calculate. I hired my first subcontractor, a sharp analyst who'd been laid off from a competitor and knew how to build the reporting dashboards clients actually wanted instead of the ones vendors thought looked impressive in sales decks. Dalton and Reed sent the lawsuit threat in writing exactly once. Their outside counsel, a mid-sized firm I recognized from vendor disputes, sent a cease and desist letter claiming breach of fiduciary duty and misappropriation of client relationships. I forwarded it to an attorney I'd worked with on contract reviews over the years. She read it, laughed, and wrote back a response that politely explained the legal definition of client relationships as property versus the reality that clients are autonomous entities who make their own purchasing decisions based on their contractual rights. We never heard from them again. Marcus lasted 4 more months. I heard through a former colleague that the board had questions about the sudden client exodus and the revenue gap in Q4. Apparently his explanation, that a disgruntled former employee had sabotaged the company, didn't hold up well when they reviewed the termination documentation and found no actual evidence of misconduct in my file, just Marcus's signature and Danielle's witness line. He took a position at a fintech startup in Austin. I looked it up once, briefly, then decided it didn't matter. What mattered was sitting at my kitchen table on a Friday morning in June, 18 months after that 4-minute meeting, reviewing contracts for clients who called me by my first name and trusted me to tell them the truth. I had 23 active clients by then. Revenue had stabilized at a level that let me hire 2 full-time employees and turn down work that didn't interest me. I'd learned to say no, something 17 years of corporate reliability had never taught me. Thompson Industries sent a gift basket when they closed their largest deal of the year. The card read, "Thanks for keeping the trains running while we chase the big wins. None of this works without you." I kept that card. Not because I needed validation, but because it named something I'd always known but never quite said out loud. The quiet work matters. The unglamorous reliability. The contracts nobody reads until something breaks. The institutional knowledge that lives in accordion folders and old emails, and the memory of someone who stayed long enough to see patterns. Marcus and I met one last time, though he didn't know it. Small claims court, downtown. I was there as a witness for one of my former colleagues, Javier, a project manager they'd pushed out under similarly vague allegations after he questioned some revenue recognition practices. Different case, same pattern. Dalton and Reed's counsel argued that Javier had been insubordinate. Javier's attorney asked for documentation. There were emails, of course. There are always emails. I watched the judge, late 50s, gray hair, the posture of someone who'd seen every kind of corporate stupidity, read through the printed threads, page after page of Javier asking simple, precise questions about why numbers were moving from one quarter to another without corresponding work. Then she reached the email from Marcus, the one where he wrote, "We need you to be a team player, not a compliance roadblock. If you can't get on board with the new reporting strategy, you may not be a fit for where this organization is headed." She read it twice. Then she asked a question I'd been waiting 17 months to hear someone in authority say out loud. "Mr. Webb, are you instructing your employee here to ignore established accounting standards in favor of presenting more favorable quarterly numbers to stakeholders?" The room went very still. His attorney objected. The judge overruled. Marcus tried to pivot, to translate his own words into alignment and strategic vision and proactive storytelling of our metrics. The judge held up the email. "I've read the story," she said. "I don't need the marketing pitch." She ruled in Javier's favor. Wrongful termination, damages awarded. Recommendation, strictly informal but carefully worded, for the board to review internal practices given the concerning language in management emails. Afterward, in the hallway, Javier hugged me. He'd used the same attorney I'd referred, the same one who'd written my response letter months earlier. "You started this," he said. "No," I told him. "Marcus started this. I just stopped pretending not to see it." That night, I sat again at my kitchen table. Same oak surface, a few more scratches now from laptops and contract binders. No severance agreement, no termination letter. Just a fresh stack of folders, digital this time, with my logo in the corner. Conway Consulting wasn't flashy. We didn't have a mission statement on the wall. We had a simple premise. Do the work well, tell the truth, write contracts people can actually understand, and remember that relationships are not line items. I think about that dusty accordion folder sometimes. How close it came to being thrown out during an office move. How easy it would have been to trust that someone else would remember what was in those old agreements. But the thing about quiet competence is that it accumulates. Every clause you fight for, every email you write carefully instead of quickly, every time you choose precision over performance, it all goes somewhere. It sits and waits, patient, like paper in a box in a hall closet. Until one day someone mistakes your calm for weakness, your loyalty for expendability, your silence for consent. And then a judge reads the emails, and a CEO reads the clause. And the story everyone thought they were writing about you, disgruntled, obsolete misconduct, gets replaced by the one you were quietly authoring the whole time. Not revenge, not spectacle, just alignment between what was true and what was finally, publicly, undeniable. That's how I lost my job and got my life back. Not with a dramatic speech in a conference room, not with a viral post online, but with a dusty folder, a kitchen table, and a line I wrote in a contract 15 years ago because it seemed like the right thing to do. In the end, that was the only revenge I wanted. To live a life where doing things the right way turned out not to be naive, but simply early.